morning. I think it's time to start. My panelists, you ready? Yes. Good. So good morning. My name is Nathalie Laneret. I am the Director for Privacy Policy at the Center for Information Policy Leadership in Brussels. And I'm delighted today to moderate this session on changing technologies and laws. How can accountability be a key to global compliance? And thank you very much to TrustArc and to Paul for making this session possible. So, what are we talking about? As you know, data protection policymakers are flourishing with new projects to regulate new technologies and in particular AI. We have more than 50 national AI strategies, including presentation yesterday of the Dutch strategy in Brussels, EU Parliament resolution on automated decision-making, numerous initiatives from data protection authorities in Europe, but also globally, including Asia, and last but not least, and also Latin America, thinking about Brazil, and last but not least, the EU Commission initiative to regulate AI within 100 days of taking office, and industry calling for regulation. But still, it looks like we're still running behind something. And it seems that it's hard for policymakers, lawyers, to actually grasp this changing environment and this changing technology and AI and machine learning. And I'm not sure we have found the secret formula yet. But today I have a panel that will bring, I hope, this part of the solution. So with that, I'm glad to present first Lauren Bourke, who is a policy analyst at the Digital Economy and Policy Division at the OECD. Next to Lauren is Carole Evrard, who is attorney at the Brussels Bar and member of the Stibbe law firm, and she's working with clients on privacy and AI, and she's also helping lawyers on the digitalization of the legal profession, which is not an easy task, being a lawyer myself. Then we have Paul Breitbarth, who is Director of EU Policy and Strategy at TrustArc, and Paul also teaches privacy at the University of Maastricht. And finally, we have Peter Kimpian, who's Program Manager at the Data Protection Unit of the Council of Europe. Before we start with our panelists, I just want to, thank you for giving me this. I just want to present actually the vision of CIPL on this topic. Very briefly, how do we work on policymakers and regulators on the topic of accountable AI? We have a special project on this, including with the EU Commission. And we're working with leading organizations to actually collect best practices that organizations are putting into place to address those new challenges and to try to reconcile the current data protection laws and these emerging technologies that create a tension with those traditional rules. We have actually developed a layered approach to regulating AI, which is based on three main layers. The first one being look at the existing regulation and, of course, data protection regulation. And here you have an example of how actually the GDPR already provides for a good basis for the regulation of AI, either because it generally regulates the processing of personal data and AI is generally powered by personal data, but also those specific provisions that are specifically relevant to AI, and I'm thinking in particular about the fairness principle, automated decision-making, or the obligation to perform a DPIA in case of new technologies, just to cite a few examples. The other thing that we want also is to make those data protection rules not only protective of individual rights, but also enablers of AI. And it's really important, actually, to try to resolve some of these tensions that we see between, for instance, data minimization and broad access to data that is needed for AI. Of course, we also want to leverage the work that has been done, for instance, in the EU, but the EU is an example, but the same should be done also in other regions. So you've heard about the high-level expert group of the EU Commission that has issued those guidelines for trustworthy AI. And what we've done here is trying to map those key principles that they have issued to the GDPR, somehow to show that whenever you start talking about this topic, you're going to bump into data protection laws. Second layer, we want, of course, and this is the core of our topic today, we want also to leverage and incentivize accountable AI. And we're not talking about a topic for the future, we're talking about the topic that is happening now. And companies, organizations, private, public sector are working hard on this and are developing practices on the basis of some of the tools that they have put in place to comply with data protection law, somehow to expand, to augment them, to be fit for the AI age. Just to give you a few examples, and I forgot to change the slides. We think that, for instance, in the area of impact assessment, I will explain to you in a minute what this is, this beautiful wheel. But we think, for instance, that in terms of risk assessment, assessing the risks of AI, there's a lot that can be leveraged from what we know in the EU as being the data protection impact assessment. And we think that tools that some companies are working on, and some have been described at this conference in more detail, such as algorithmic impact assessment tool, fairness tool, could be further leveraged in the AI context. And we think that these risk assessment, these impact assessments should include not only risks to AI, but also benefits of AI and reticence risks, which is what would be the effect if we decide not to go forward with this AI solution. So very briefly, because I know that the panel is really waiting to talk, and the accountability wheel that you're seeing is really how we see how organization can make data protection effective within their organization. And you have a set of 7 core elements that are key to making this work within the organization, and we think that this can be leveraged in the world of AI. That you need to have tone from the top. You have to have support from the board. You have to make risk assessments because not all AI is the same. You have, on the basis of these risk assessments, implement specific policies and procedures. Of course, you have to be transparent to all stakeholders. You have to train your teams on the AI challenges. And most importantly, you have to audit. You have to make sure that what you ask your teams to do is actually done. And if you find things that are non-compliant, it's actually a good thing. It's a good thing because then you are able to correct it and address it. And finally, response and enforcement, you have to be able to address those cases where things do not go as anticipated, so that you are able to constantly improve and adapt to changes, to new technology, to new businesses. This wheel actually requires organizations to show that they are cognizant of the risk of the environment and they take that into account. And for each specific tower, you have a few examples of what companies have been doing specifically for AI. And on top of that, this is the third element, and then panel will talk, is the regulator's role. We need modern regulators. We need modern oversight. We need more solutions like sandboxes, where companies are able to have a safe space where they can discuss innovative products, innovative AI technologies, and try to reconcile together with the regulator, reconcile it with those privacy a principle. And finally, we need more cooperation between different regulators. We need regulatory hubs to avoid divergent interpretation. So with that, I'm going to ask each of the panelists to present their view on the topic and how really we can further leverage this to provide for balance and good regulation, whatever that means, or maybe smart regulation for AI. And what do you think maybe of the approach? And please, if you disagree, I'm happy to hear it as well. So Lauren, can you tell us a little bit where the OECD is on accountability in the AI world, and maybe talk a bit about accountability 2.0, and this is working. Okay. Thank you. Lauren?
Perfect.
Please.
Thank you, Nathalie. And thank you also to TrustArc and to CPDP for the invitation to speak here today. I'm very excited to be here. So I am a policy analyst at the OECD, and for those of you in the room who maybe aren't so familiar with the OECD, it is the Organisation for Economic Cooperation and Development. It's an international organisation. We have 36 member states, and it's really tasked with providing a platform for countries and experts to get together and talk about these issues. We also produce a lot of guidance and frameworks for member countries, including in relation to AI and privacy. So the question that I have been tasked with today, sort of generally, is to talk about what data protection accountability looks like now and what it looked like when it was first conceived in 1980. And that's directly relevant to what I'm doing at the OECD. My team is tasked with reviewing the OECD privacy guidelines. They were initially drafted in 1980. They were the first international privacy guidelines that were accepted by countries worldwide. And what they represent then and still to this day is the minimum standard for data protection and privacy. So in contradistinction to the GDPR, which a lot of people say represents the high watermark, we represent the minimum standard for countries, particularly those now that don't have the expertise to be able to implement something so sophisticated as the GDPR. So accountability was one of the original principles in the privacy guidelines in 1980. And the privacy guidelines provided that a data controller should be accountable for complying with measures which give effect to the general principles. So what I think we saw back then is that accountability in 1980 was synonymous with compliance. So the explanatory memorandum to the privacy guidelines spoke about accountability in quite general, broad terms. It said that a data controller has the onus of being accountable, notwithstanding whether or not that data leaves or is carried out by someone else on behalf of the data controller. But what the privacy guidelines in 1980 didn't specify is for what or to whom the data controller needs to be accountable. And in many ways, privacy accountability remained quite an elusive concept, which underscores the need to introduce further clarity. So since 1980, as we all know, the recognition of the importance of accountability has increased exponentially. So in 2013, there was a review of the privacy guidelines, and I should maybe just interject and say at this point, I think it is relevant to talk about the history of the privacy guidelines and accountability, because the OECD has just come out with AI guidelines or principles, one of which is accountability, and we're drawing quite heavily on the lessons that we've learned from the privacy context. So the 2013 revision had a section that was introduced that was called Implementing Accountability. And this was introduced after extensive conversations with member countries and with an expert group comprised of over 60 experts. And under the new revised 2013 guidelines, privacy management programs are the primary operational vehicle by which organisations could demonstrate accountability. So what are privacy management programs? We all know, but there was sort of a three-prong approach in the 2013 revision. First, having like a tailored, integrated and periodically assessed privacy management program with appropriate safeguards. What are appropriate safeguards? Some guidance was given to countries, including contractual provisions, employee training and education, audits and processes for notification of data breach. So a lot of the factors that are on the CPDP accountability wheel, also a lot of the other safeguards, that we see in the GDPR now. So providing notice for a significant security breach was something that was also really highlighted. So now, where are we? So I am currently working with the team to conduct another review to see whether or not the 2013 revision really went far enough and where privacy is now. Obviously, since we've had the introduction of the GDPR, so the privacy landscape has changed quite a lot since 2013. I have about 5 more minutes, but I sort of think that there's maybe some merit to talking very briefly about what that review entails and sort of what are the high-level outcomes that we are seeing at the moment. The review hasn't concluded, but there are some really interesting takeaways that are quite relevant to the AI context as well. So the review that we're now conducting has a few different components. We've conducted quite an extensive questionnaire of countries where we are asking countries, what are you doing with privacy? Where do you think privacy is going and data protection more generally? And how do you think the privacy guidelines need to be amended? We also have a series of different expert consultations. We have over 60 experts in the field that come to the OECD and talk to us about these emerging issues. We had one on accountability in May last year. And we're also hosting some other side panels and hearing what everyone is saying at events like this to be able to take that back and look at how we can give guidance to countries and how we can really help. So a few different takeaways that have come out of this review and what is accountability. The first is exactly that, like what is accountability? What do we mean? How do we define it? And I've heard time and time again that the word accountability is quite a vague one, especially when you consider how it is translated into other countries. If you translate accountability in French, it means responsabilité.
Can I just say
yes,
one
please.
thing?
Yes.
Sorry. I think the translation in French is not a good one because when you look at the Spanish one, it's much better. It's a responsabilidad demostrada. So I don't know, I'm sorry for the person who translated it, but it should have been responsabilité démontrée or something like that.
Yeah, and I agree. And I think that's consistent with how our conception of accountability has changed. So in 1980, accountability was associated with compliance. Are you complying with your legal obligations? Whereas now we see this move towards accountability 2.0. Mm-hmm. And this is sort of what you're suggesting, that accountability means so much more than just being responsible. It's sort of being interpreted, and I think this is the confusion because it's being interpreted in so many different ways. So there's a lack of clarity there. But I think accountability 2.0 is moving towards a meaning of accountability that means being responsive and transparent and ethical and proactive in terms of, complying with your obligations is one thing, but you need to incorporate this into your actual business and be proactive. And of course, that's very difficult for a lot of organisations to do. There was a panel yesterday where, one of the panellists was saying for large organisations, it's almost impossible to implement an effective privacy management program, let alone for SMEs. So maybe wary of the time, and I'm happy to talk about this more, in terms of how our conception of accountability has changed into this sort of almost a verb as to how you are being held to account and what you are doing to be accountable. And I will wrap up now, and I just say one of the other major sort of takeaways, aside from our shifting definition of accountability, is the role of enforcement. So you can't have accountability without liability, mm-hmm. and that it is not enough to operationalise some sort of conception of accountability without also having a robust oversight regime, external scrutiny about privacy management programs and how organisations are sort of trying to demonstrate their legal compliance. And yeah, I think maybe I'll conclude on maybe a little bit of a controversial point. Some participants have queried the success or even the implementation of accountability, recalling that it was introduced in 1980, yet the trust deficit today is higher than ever and data breaches have far from stopped. So I will leave it there, but very happy to discuss further and answer questions.
So, Carol, can you give, please, the view more of an industry? And, I mean, what do you tell your clients? What do you tell them about accountability and enforcement and what they should do or not do?
Thank you. Thank you, Nathalie and Lauren. And actually, I see my fellow panelists nodding, so I think we will agree on many topics. I'm also happy to see that probably on other topics we will have discussions among us, including tech neutrality, but I will come back on this later. So indeed, the regulatory landscape is changing fast, but the technology is changing even faster. And in practice, I can tell you that when clients come to us willing to launch new innovative products and willing to comply with their legal obligations, most of the time we don't immediately find the answers. And that's why our work as privacy lawyers is so challenging, is that we need to help them comply with non-yet regulated innovations and products. And how we do that? We basically try to build up on existing legislation, it being civil law, contract law, or even construction law when it comes to IT projects, for instance. So what we see also in practice is that new regulation usually cannot keep up quickly enough when it comes to innovation. And I can give you one concrete example, and it also comes to the topic of tech neutrality. If we go into the sector of telecommunications and OTTs, so OTTs means over-the-top services. So a few years ago, OTTs were spreading all over Europe. And they were still regulated at that time by a directive dating back from 2002. And that directive was regulated what we call ECS, so Electronic Communication Services. And they were defined as services consisting wholly or mainly on electronic communication signals. And so at that time, and well, that's what we tried to argue at least 30 years ago, we can't believe that the legislators really had in mind the possibility that those signals could be also routed on the internet. And so there's been a lot of discussions in which we were involved about whether services such as Skype and Skype Out, to be fully concrete, should fall under that specific old category of ECS and be regulated. And so the old debate was also about what I'm not afraid to call the myth of net neutrality and tech neutrality, which we can discuss further if you want. But so when we were discussing this, and this discussion went all the way up to the European Court of Justice, the EU regulators and legislators were discussing about the adoption of a new code on electronic communication. And they they created a new category for this specific sort of OTT services to make sure that they would be regulated under the new code. But so all this to say that one should not forget that usually rules are adopted to deal with existing or at least predictable situation. And it would be unrealistic to think that ex-ante regulations could really regulate innovations because innovation will continue to evolve even more quickly. But so, and to come back on the core of the debate about accountability, could accountability be a solution to this problem? In my view, it could be part of the solution indeed. So accountability, as the EDPS would say, is not an end to itself, it's a means to an end. It's being really compliant and being transparent about how you you comply with your obligations. In the GDPR, it's a very transversal and abstract principle, which is implemented in many concrete obligations. But Nathalie explained that already in her beautiful slide at the beginning of the presentation. But so the GDPR puts that burden of complying with this principle of accountability on the data controller. And in practice, the qualification of different entities engaged in a commercial relationship as data controller or data processor or co-controller or separate controller is really a difficult one. It may seem completely theoretical, but in practice, and I have to admit, even within my team, we sometimes have debates and we don't agree on how we should qualify each entity involved. And that has massive consequences in practice and about the obligations of each of them. Even us as lawyers, well, a few years ago, we used to receive DPA, so data protection agreements, from clients, asking us to sign them because they would consider us as data processors, because they were thinking that we were acting under their instructions, and therefore we should qualify as data processors. So at that time, we had to think about it and to make that assessment ourselves, and we realized that we have such an independence in the way we handle their files that we cannot be qualified as data processors. But just to illustrate that it's not a theoretical question. About AI, about accountability. Accountability is important, but in my view, it should not be limited to accountability in the way it's presented in the GDPR. First of all, because AI and big data and many new technologies don't always deal with personal data, but most of the time also with non-personal data. And also because of this very blurry border between the different concepts of data controller, data processor, and other parties involved. Regarding the GDPR, there are many areas of tensions, of course, between the privacy principles and new technologies. And you had plenty of opportunities these last days to listen to experienced speakers talking about them. So I'm not going to go too much into details, but I can confirm that usually companies sit on a very large amount of data they collected in the past. Sometimes they don't even recollect how they collected it. And so they want to use such data for new functionalities, for new applications. And they come to us and they ask us, what can we do? How far can we go? Who can access that data? Do we need to ask any consents from any people? So those are the sort of questions we receive. One of the answer could be anonymization, of course. As you probably all know, the interpretation of anonymization is very strict. And, well, I'm a mere lawyer, I'm not a technician, but I attended yesterday a very interesting panel here about data analytics and AI and how we really lack industrial practice, industrial guidelines about how far you should go to really reach that point of anonymization and not stay within the layer of pseudonymization of data. But so, even in that respect, in respect to non-personal data, as you know, we have a regulation on the free flow of non-personal data. And in relation thereto, the question we often face is the question of the ownership of the data, of the non-personal data. And to be fully concrete, and let's take a real-life example. So, traditional bank trying to really engage in digitalization and willing to create a new product based on the outcome of data analytics that they would have performed about the data they already have in their companies. And the question is, how far can they go, and do they need to ask any consent? How do they comply with their transparency obligation? Can they contractually say that they are the owner of the data? And what ownership of data would even mean in that case? So I'm sorry, I feel that I'm raising more questions than providing answers, but just to give you an idea of the gaps we see in practice. And maybe quickly to conclude, I would like to say a few words about one presentation that I attended last Monday, given by the CEO of Google, Sundar Pichai, about responsible AI. Because he was explaining that AI is evolving so quickly that things that would appear legally or ethically tricky today would probably be largely and widely accepted in a few years. And so it really calls for a regulation of AI, but on a broader level, and really building on strong foundation that are existing laws. And he also cited this principle of accountability. And so I fully share his view. I just still believe that the principle of accountability must be clarified, cannot be limited to the accountability that we know under the GDPR, because so many different providers now are involved in the projects, and their respective responsibility, and also the question of responsibility and accountability is very important, because in practice we see many what we call RACI table, where different parties engaged in a project allocate contractually their respective responsibility by saying, you are accountable, but I remain responsible. But all this, I think, should be not contractually stipulated, but really regulated by law.
Thank you, Carol, for this very thorough presentation. Just very briefly, thank you for clarifying that accountability is not an end in itself, but it's a journey. And it really goes back to what Sundar Pichai was saying, that accountability really fits well with technology because of this journey characteristic, I would say. And it's really, just to give you a concrete example of what at Tipple we see accountability being, it's really about turning these principles, if we take, for instance, the fairness principle of the GDPR, into concrete, actionable, demonstrable, and enforceable obligations. So if I'm deploying an AI system that has to be fair, I'm going to have to set up tools, processes, train my team, and set up controls, testing, to make sure that my AI system is fair, so that I comply with those principles. So in other words, it's very concrete. That's why all these examples from organization are key to collect, so that they can also be shared and become maybe industry best practices. And with that, now it's the perfect time actually to have Paul maybe talk about a little bit the limits of this. Like, I mean, aren't we going to bump somehow into some hard stop by trying to stretch those principles and operationalize them? Paul?
No, I don't think so, actually. I think these principles are principles for a reason, and most of these principles have actually been in place since the 1980s. So, well, we can celebrate a lot in 2020, including 50 years of data protection laws in Europe and 40 years of accountability for data protection across European countries and even some North American countries within the OECD. But I do think those principles have survived all those years for a reason. If we look at the evolution from the Directive 95/46 to the GDPR, I deliberately say evolution, yes. Because it was a relatively small change. Not for many organizations in implementing it, but if you look from the legal perspective, it was a relatively small change because all those concepts stayed the same. And I do think also going forward, those concepts like transparency, like the requirement to have a proper legal basis, like the concept of being accountable and taking responsibility to be able to demonstrate that compliance on an ongoing basis, that they will also be important, whatever technology we are looking at. Today, artificial intelligence is hot, blockchain is hot, automated facial recognition is hot. Who knows what next year or 2 years from now will be the hot technologies that we will be discussing at CPDP or other conferences around the world. For me, what stays the same is the fact that these technologies will need to comply with the legal framework that we've developed with each other. And that is not just the GDPR. This is a global issue. And also from that perspective, I think it is much more important to agree with each other on what the foundational principles are that we are looking at a global perspective, and that we can then implement in the various laws based on our cultural and legal traditions, than just saying, oh, we need more custom legislation. I don't believe that legislating AI specifically is a solution to the challenges that we're facing. And let me just name a few. One of the main challenges that also makes people uncomfortable is what is happening with all that data? What are people, what are companies, and what are government doing with my data? The outrage about Cambridge Analytica was not so much the fact that data was used, but that nobody knew how their data that they thought was just for a game, how they had been misused for other purposes. So transparency is one of the key elements if we want to get back to a better understanding of what is happening around the world. And Lauren mentioned the trust deficit is higher than ever. And I agree with that, but I don't think that is due to a lack of accountability. To some extent, it is due to a lack of accountability, but it is also due to an increased awareness by people that their data is being used and that they mistrust what is happening there. And to rebuild that trust, I think you need better transparency. And that also applies to Mr. Sundar, who may want to do more with data, but also could do a lot better in explaining how these data are used. Not only what data set are being used, but also how they are actually using that. What are those algorithms? And yes, it is very difficult to explain an algorithm in natural language to people who are not familiar with the technology, but I do believe that it is important that we make a much better effort in doing that. For me, the standard is always, can I explain it to my parents? For others, it is, can I explain it to my children? But that is, for me, where you should take a look at. On the other hand, it is also important that legislation doesn't hinder the innovation and the development. We need these new technologies to move forward in society. And if you look, for example, at artificial intelligence or also other research projects that are going on, one of the main conclusions that we can already draw is that there is a lack of training data. There is a lack of data that is available for research purposes, for training purposes, for AI in a proper manner. And yes, accountability can play a role by explaining again what you are doing, how you are doing it, how you are securing those data, how you are protecting those data. But that doesn't always solve the problem of the legal basis of the compatible use. There are possibilities for that also in the GDPR, but they are not sufficiently used. If we look at the compatible use principle, there are ways for governments to make legal conditions to allow for easier use of data sets for specific purposes, also for sensitive personal data, for the special categories of data. But if you look at Article 9.2J of the GDPR, the research exception, that is one of the opening clauses that has hardly been implemented by the member states, making it very difficult for researchers to use that data. On Monday, I was part of a roundtable discussion of Maastricht University on the ethical use of data for healthcare research. And the Finnish, somebody from Finland actually explained Finn data during that session. You won't be able to see all these slides. I've got a copy here, but what Finland basically did is create a new legal basis that allows researchers access to all the government databases if they have a specific research plan in mind. That could be for scientific research, it could be for statistics, but it could also be for development and innovation, so for training AI, for example. You will need a permit from a special data authority, the Health and Social Data Permit Authority, that will assess whether your research project meets the standards. But once you have that permit, you are allowed to use all kinds of individual and statistical data from the National Institute for Health and Welfare, from the Digital and Population Data Services Agency in Finland, from Statistics Finland, so the general statistics, but also insurance data and healthcare data. So a large set of data, and I think this is a very good example for a lot of governments to follow to make more data available in a proper way with controls in place, because there is a permit system and there is also agreements on how that data can be used, how long it can be used, and also what has to be done once the outcomes of a research study are known. Maybe to wrap up, EDPS recently released a first draft of a study, of an opinion on also using research data on research under the GDPR, mainly health focused, but some of the lessons from that paper can also be used for new technologies, whether AI or other. And also the EDPS recognizes in that paper that accountability principle is a key to work towards compliance, to make sure that a controller assesses honestly and manages responsibly the risks inherent in their research projects. And the honesty and the responsibility for data controllers, that goes back to the 1980s principle from the OECD guidelines, and that is something that we can build on going forward in decades to come, I believe.
Thank you, Paul, and thank you for being so precise and providing example of FinData, which is a country, solo country initiative, I would say.
Yes.
But accountability also enables to drive global consistency, because organizations, when they develop their program, usually they develop a global program based on one standard that is then tailored to each specific country, but then it is a driver of convergence internally. And now I'm going to ask Peter really to talk more about how to drive global convergence through accountability, and to present more, or to present actually what is the Council of Europe doing on this topic.
Yeah, thank you very much. Thank you, Nathalie, and thank you very much for having me on this panel. I'm truly delighted and honored. Really briefly about Council of Europe as a matter of introduction. It's a regional international organization with 47 member states created after the Second World War, basically to keep peace and stability at the continent. We have 47 member states and more than 200 conventions which are binding, and we have the European Court of Human Rights, which can issue binding decision on countries. Among these conventions, we have open conventions that not only member states can sign to it, but third countries. This is the case for our instrument on data protection, which is the Convention 108. As we attach a number to each convention, the Convention on Data Protection is the Convention 108. It's an open convention, the third country can join to it, and we have currently 55 parties to this convention, 47 member states of the Council of Europe and 8 other countries who decided to join this convention. This has been open to signature first in 1981. So it's really in accordance, and it was really in synergy with the OECD guidelines. And at that time, it really centered Europe and the European continent for a more modern, at that time, instrument which could allow the protection of individuals. And I remember, I draw your attention that at that time we had in a Cold War situation. So it was a very interesting development, that stage. But during the age, we thought that, and other countries thought that they would wish to join this club of countries which have a similar level of protection of personal data, basically for two main reasons. Because the convention, as of 1981, has based itself on two main principles. One is the protection of individuals, so for protecting individuals and individuals' data in an appropriate level, and to ensure free flow of data between parties. But as this instrument has been elaborated in 1981, of course it needed some modernization, and this modernization process took us 7 years. And also partly because we wanted to wait the European Union to finish its instrument, namely the GDPR and the Police Directive, to take also this into account in our modernization process. And I think this is a success story, at least in our continent for now, because we managed in last year to have a consensus and a text which has been adopted in a unified voting mechanism. So it's a wide consensus that data would have been protected according to the principles that the modernized convention puts forward in the modernized text. And I will speak about a little bit on the accountability part, and we fully share the views that has been already presented about accountability 2.0, and we believe that to reach accountability and to achieve this, it's not enough to speak about responsibility. Only it's very important, but we need to create an ecosystem where every actor has its own role to protect individuals and maintain the free flow of data. So the accountability principle is in Article 10 of the Modernized Convention, and I will not cite any legal text, but basically it means, and it puts forward for data controller to think over about the data processing operation, think over if you apply the right set of safeguards, if you have the appropriate security measure, a policy for the data breach modification, if you ensure transparency, and more importantly, specific rules on sensitive data and on processing sensitive data. Very uniquely, the Modernized Convention foresees that sensitive data can only be processed if appropriate safeguards are in place, which are complementary to the one that has been foreseen for the so-called normal processing of non-sensitive data. But it's fine that we have all these in the convention, but how would this be implemented in public authorities, being in a federal states, for instance, or centralized administration, or private entities, also multinational companies which are now putting in place new type of data processing in their products. So we also have additional provisions in the convention itself, like in Article 10.2, we foresee that the data controls has to comply or has to apply the data protection by design approach. And also in Article 10.4, the data protection by default approach also is in the convention. A mention about data protection officer, what we also see as a guarantee to compliance or kind of a measure that can help compliance and overall accountability. It's also mentioned in the explanatory report. But more importantly, we also have told that it would be important to empower also the individuals to, if things are not going well enough, that they could enforce their rights, so that they can claim to come back to normal and to get back the control of their data. And those rights are in Article 9 of the Modernized Convention. First and foremost, there is a new right, which also you can find, of course, in the GDPR, but we, with the convention, can bring into a global perspective the right to know the reasoning of the data processing. The other right is a right not to be subject to an automated data processing without taking the data subject's views into account. And there is also another important new right, the right to object. Parallel to this, if, of course, the data controller and data subject cannot make a term into their difference, there is a supervisory authority, of course, which the convention foresee to put in place in every party as of 2001. But in the modernized regime, they will have their power enforced. And I would draw your attention to Article 17 and 18, which are quite unique in my sense, because they foresee an obligation for data protection authorities to cooperate And it's something which has been around in the past, but it has been like a choice that the data protection authority could make. But now here we talk about an obligation, and there is a list of areas where they can cooperate, but there is also joint investigation mentioned, and enforcement procedures across the border.
That would also then apply to the non-European DPAs, right? The
Yes.
non-European oversight bodies.
Yeah, exactly. So as I mentioned, we have 8 non-European parties, and several others are considering joining the convention. So it would really mean a global protection framework for individuals, which is building up step by step, but it's a quite steady and progressive process. We had, and I'm very frank with you about that, we have a major gap in the recent part, or the recent regime of the convention, which is the monitoring and the follow-up, the lack of the monitoring and follow-up mechanism, which other Council of Europe committees have, but we didn't have in the past. But we will have this Committee of Convention 108, we'll have the power and the ability to monitor the implementation of the convention in their parties, which would mean that it could also go up to the international level to engage a country in terms of if they in terms of their accountability, and if they comply with their international commitments that they took regarding data protection. Parallel to this, we have several soft law measures, which has been quite influential already in the past. And to name just a few, which can be very important in the new type of data processing, such as the AI or big data data processing, we have 2 guidelines which are basically based on the precautionary approach that recommend the developers, the users of this technology, and the state to apply this precautionary approach, which means do no harm and safety first principle. We put also in these recommendations, in these guidelines, at the center of our attention, the individual control, and we foresee some measures to implement by the developers and also by state actors to ensure that the control remains at the with the data subject. We also have an approach which would imply that an ethical and social impact of the use of this technology would be taken into account, or we would recommend that this is also taken into account, not only the mere impact on the company itself or on the data subjects that are in direct contact with the company. Of course, we foresee avoiding mitigating potential risk and to apply fully the data subjects' rights that are foreseen in the modernized version, including the new ones, which we believe would be a really an important and effective tool in the hands of individuals, together with data protection authorities, together with the monitoring mechanism of the committee to really create this ecosystem where individuals can be protected even at the digital age, in the digital age.
Thank you very much, Peter. I picked up the notion of the accountability of countries. I'm not sure this is the place to discuss this. There are other forum and places to discuss this, but I liked it. So I think it's time to open the floor to questions, and I know there are questions. I know people have questions in the room. So please, I think you need to stand up and go to the microphone.
Hello. Well, very glad for the panel. Very nice contributions. I'm also glad that Paul and Thiago from the DPS. So I'm glad that you mentioned our recent publication scientific research, because it's this way of bringing this topic to discussion, like what you said, that people are not, like national member states are still not considering how to reach that topic. I have two questions. One is for you and one for Carol. So for you, since you talked about some red flags that should be taken into account to avoid that over-regulation stifle innovation, could you bring what you consider at this moment, which could be these red flags that regulators should think twice before going beyond what would be reasonable? And the other for Carol is in the other way. You're talking about many gaps that we still have. And okay, what could you, if you could give us a priority number one in terms of a guideline, what would that be?
Thank you, Thiago. So who starts?
Ladies first.
Okay, I'm still writing the question.
Okay, nice, huh?
No, but it's fine, and I can actually also address maybe the first one, because both. But
Yeah,
we'll see what you have to say. About regulators. Well, the question of tech neutrality is also, I think, related to this, because the idea and the principle is a good one, of course, and it means that we need to regulate based on broad principles instead of obligations that would be related to specific functionalities, for instance. If you take the example of telecommunication and Skype that I gave you, the problem there was that, regulators love to regulate, right? So if they try to do that in a premature way, the risk is that you try to completely impose one set of rules to a new product that is not even able to comply with those rules. So in the case of Skype, basically now they're supposed to comply with the laws applicable to traditional telco operators, while technically they can't. And basically the problem there is that now they're engaging with the Belgian regulator, trying to find solutions, and the Belgian regulator doesn't even know what they're supposed and how they're supposed to comply with the obligations, because the legal framework was not yet ready for to be imposed on these sort of new players. Do you want to go on with this one?
Yeah. So when you speak about red flags for innovation, I think one of my red flags would be to over-regulate a specific technology. I think one of the good things about GDPR, how challenging it may be, is that we have tried to make it technology neutral as much as we can. Because if the legislator wants to regulate technology, you're always 2 or 3 years behind the fact, at least. And I'm not talking about e-privacy, which might even be 6 years behind, or 7 years. So you need to stop over-regulating and indeed look at these things with a technology-neutral lens. And that also means that for regulators, it is important that if they do provide guidance on a specific topic, that they use their interpretation, but also they're trying to keep it as open as possible. And I'm specifically looking right now at the legal basis and the facilitation of access to data, especially in research scenarios, whether that is indeed for AI or other technology-driven research. I think that should be possible. I think access to data for technology research is relevant. And yes, officially, according to GDPR, we are looking at scientific research. But as the EDP has also rightly mentioned in the paper, it has become a bit vague when something is scientific research, when it is commercial research. Does it always need a university or a research institute to be part of the research, to be scientific research or not? So you also need to distinguish between the research as such and then the subsequent use of the outcomes of the research, the operationalization of that. And there you can be much stricter in how and when data can be used.
Great, thank you.
I think we didn't answer your second question about the gaps in the law. Your second question was about the gaps and what we can do. But so in practice, two things maybe. In practice, what we rely on very much are existing guidelines. because of course there might be gaps and there will always be gaps, but we need clear guidelines, clear recommendations from the DPAs, from other bodies, and they do that very well. Also in the private sectors, I mean, companies invest a lot in their compliance program, and I strongly believe that we should incentivize codes of conduct and the development of those sort of instruments that also us as lawyers we can use to interpret the law and maybe fill the gaps that will always be there in the law.
And maybe there are no gaps, maybe they're just, we need to have more progressive interpretation.
Yes, because also a call to companies who want to do more with the data they have, take the risk. Make your own interpretation of the law and don't wait for the supervisory authorities or the legislator. Because we work on the basis of principles, you have that possibility. GDPR is open norms based. A lot of privacy law is open norms based. So make your own interpretation, defend it tooth and hand, and make sure that it holds up in court.
Can I maybe as well,
Quickly, because we have another question.
of course, reiterate the importance and how often we are being told that, you know, we need more guidance, and, you know, the notion of a privacy management program is like one of the fundamental parts of accountability, and it's been around for a long while. But the IAPP EY 2018 report, which was also part of the GPEN data sweep in 2018, reported back that only 32% of organisations have a mature privacy management program, and 56% of them report having or being far from having a sophisticated privacy management program, or will say they will never comply. So I reiterate, like, yes, go for it, absolutely, and we will try and give guidance, you know, as much as possible.
So please introduce yourself.
Yes, Mark Nijssen from the Flemish Data Protection Commission. I completely agree with what Paul said, that we have the main fundamental principles on which GDPR is relying. But I would like to put forward a problem that occurred in a previous session here, namely about the WHOIS service concerning the domain name system of the internet. And I was really appalled that many members of the committee there were proposing that the protection of the individual would be the good excuse to hide who is responsible for a domain. This is completely against the accountability and the transparency principle, I think, which is much more fundamental than protecting an individual who is taking responsibility of data on the internet. I would like to have your view about this. If we consider accountability essential, then we should take the consequences of this and not use or misuse the GDPR rules for individuals to go against the accountability rule. What is your view on this?
Yes, I cannot refrain in commenting on the WHOIS issue, although as Council of Europe and Special Data Protection Unit has been stay low on the latest development, but before we have been very active. So and to give a little precision to the issue, it has been like a 30 years discussion within ICANN. And it has been due to the fact that the WHOIS has been constructed, and admittedly by those who have constructed it and those who have used it, in a way that it didn't take care any of the privacy principles. Hence, it showed and showcased very intrusive and very sensitive personal data of everybody, and every individuals who have been behind the domain name system. And this privacy authorities as well and privacy advocates have been criticizing it, and it went up to the Copenhagen meeting, where the United Nations Special Rapporteur of Privacy, the DPS, And the Dutch Data Protection Authority participated in the meeting and said it cannot stay like this. And we have to think together what would be a privacy-compliant way to ensure this registry to function in the future. And then, because of the, I don't want to comment ICANN's decision, but then they turned totally down the WHOIS registry. And they are now in the process of developing a new one, WHOIS 2.0, which would be privacy compliant. But it doesn't mean that the WHOIS data, for legitimate purpose, and if there is a legal base, it cannot be accessed or it cannot be collected. It can, for instance, for law enforcement, but it's true that that the proper process are not in place for now.
I'm not sure I agree this is an accountability issue.
Yeah.
5 more minutes, thank you.
I don't agree this is an accountability issue. I've been part of some of the discussions on ICANN when I was still with the Dutch DPA and part of the Article 29 Working Party. And I do think that some data of individuals could indeed be available, should be available, at least contact records to some extent should be available. But that doesn't mean that the full WHOIS register should be available to everybody around the world. And yes, law enforcement should get access in case of a warrant or an investigation going on. But there are perfectly legal ways to do that, also part of the Law Enforcement Data Protection Directive. I think this is much more a privacy by design issue on the side of ICANN to make sure that they can serve A, the interest of the general internet user needing to contact a web host, but B, also protecting the data of the individuals.
Thank you. I just want to conclude now because we're running out of time. And just to finish, for the panelists, I'm going to ask you to select just a few words in the list I'm going to give you. We've seen that we have different layers currently. We have existing laws, data protection laws, we have accountability, so we have a nice cake. But if we were to add some sort of icing on the cake, what would it be, or cherry on the cake? So please choose 2-3 words because we are limited time. Would it be, so this cherry, would it be soft law, self-regulation, co-regulation, hard regulation, sectoral law, horizontal, principle-based, prescriptive, obligation to set up data lakes, like the one you presented? What would be your position on this, if any? Paul, you start.
Let me start.
2-3 words, huh?
Principles, guidelines, transparency.
Thank you. The transparency was not in the choice. But
I know, but I added it. I like to cook, so I add my own ingredients.
Okay, good.
I'm sorry, I will go on the same line. I will not behave very well. And add the reflections that we are currently having at the Council of Europe. As you may know, we have established an ad hoc committee on artificial intelligence, which has been mandated to come out with the feasibility and the necessity of a international legislation on AI, and we have been discussing last week what would that be. So we are currently reflecting on either a recommendation or a framework convention or a basic convention. But for
the words are going, huh?
yes, sorry.
So these are
the forms of instruments that we are discussing now. There are pros and cons for everyone, but I believe that it would be a topic of another panel.
Okay, Carol.
Yeah, I will comply with your request as we talk about compliance. I would say soft law, principle-based and sectoral-based too.
Thank you.
And I would say hard law, soft law, and if I could add another one, international cooperation about what that...
That's a great one, actually. I didn't add, but I have a hard... How can you have hard and soft at the same time?
Well, soft law is the guidance.
Okay, good. Okay,
Yeah.
okay.
But you need the enforcement to back it up.
Yes, okay. All right. So
To be continued next year.
yes, and with that, I mean, thank you to our distinguished panel, and thank you to the audience for engaging with us, and bon appétit.